Okay, so we're still in chapter 6. So the topic double sales still falls under chapter 6. So what's a double sale? There is double sale when the same thing is sold to different vendees by a single vendor. So there are elements for a double sale to exist, and that's found in the case of Sheng versus Henato. So elements, there must be 2 or more sales, and all those sales must be valid sales. The 2 or more sales transactions pertain exactly to the same subject matter. 2 or more buyers at odds over the rightful ownership of the subject matter and must each represent conflicting interest. And lastly, the 2 or more buyers at odds over the rightful ownership of the subject matter must each have bought from the same owner. So let's break down each of those elements. So the 2 transactions must be both sales, and they must both be valid. So it cannot be a contract to sell, okay, unless the suspensive condition in that contract to sell has been fulfilled. So this, the rule on double sales applies to conditional sales. So not just absolute sales, but also conditional sales. And then the double sale rule will not apply when there is only one valid sale, because the other sale was found to have been fraudulent. Okay, and as to the second requisite, there must be identity of subject matter. So if what was sold in one contract was a piece of land, while in the other contract, what was sold was the right to redeem, then there is no application of the rule on double sales. Okay, lahi man ang subject matter. So you read that in the case of this Choso versus Rojas. Okay, and take note as to the fourth requisite, the 2 or more buyers must have bought from the same owner. That means that they bought from the same immediate seller. So if the property was sold by a transferee or a successor of that seller, then that will not meet the fourth requisite. So dapat identical jud sila o seller. So once you know that the rule on double sale is applicable to a given situation, then that's the time that we apply Article 1544 and the rules of preference prescribed by that article. So what are these rules of preference? If it's personal property, then the rule is that the first to possess in good faith shall be preferred. And as to real property, na to look at tiers ang preference. The first one will be the first registrant in good faith. Then second will be the first possessor in good faith if there was no registration. And then the third will be the person with the oldest title. So prius tempore potior iure. First in time, first in right. Right? So in the double sale of real property, ang preferred dun na to nga buyer who is entitled to the property is the one who is able to register the deed of sale with the registry of deeds. And that registration must be made in good faith. Because if there is absence of good faith, meaning ma-proven na bad faith to ang nakaparegister sa sale, then that rule, that preference given to the registrant will not apply. Okay. So the rule, therefore, is that the registered transaction prevails over the earlier unregistered right, because the act of registration operates to convey and affect the registered land, so that a bona fide purchaser of such land acquires good title as against a prior transferee, if that prior transfer was not recorded. Okay, the registration contemplated under Article 1544 has been held to refer to registration under Act 496, which was the Land Registration Act, and is now called the Property Registration Decree, or Presidential Decree 1529. However, there is another act. So if the registration was made under under Act 3344, which is a separate law, it is not effective as against a buyer who registered under PD 1529 or from its predecessor na Act 496. So take note that registration, guys, as contemplated in Article 1544, has two legal meanings. So registration as the judicial or administrative process by which a parcel of land is placed for the first time within the coverage of the torrent system. Or registration as the act of annotating or inscribing a contract, transaction, or legal process in the registry of deeds, covering a property which may or may not be registered land. So the rule on double sales refers only to number 2. So ang pag-annotate o pag-inscribe. So registration means any entry made in the books of the registry, including both registration in its ordinary and strict sense, and cancellation, annotation, and even marginal notes. So it is any entry in the registry which records solemnly and permanently the right of ownership and other real rights. So annotation, guys, of an adverse claim or a lis pendens produce the same effect as formal registration. So ang kaning double sales, guys, it does not mean na only registered lands lang. Ha? If unregistered pa siya, but you are able to have a transaction or a contract annotated or inscribed with that particular land, then it is considered as registration under Article 1544. So what is this Act 3344, and why is it inferior to registration under PD 1529 or Act 496? So this was enacted back in December 8, 1926. And this is a system of recording transactions over unregistered real estate. So mga unregistered siya. So it is a law dealing only with recording of instruments relating to land not otherwise registered under Act 496, which is now PD 1529. So considering another property registration decree, PD 1529 is superior to registration under Act 3344 because the effect of having a torrents title, guys, is that it will relieve the land of all claims except those annotated or noted in the title, in the torrents title. So I assigned the case for this, the Nawaan Community Rural Bank versus Court of Appeals. So with respect to good faith of uh, the parties, guys, especially the buyers, there are cases that illustrate the good faith of the second buyer, the good faith of the first buyer, and the third case of Coronel versus Court of Appeals. Within, we will appreciate the significance of annotating lease pendants with respect to the good faith of the buyer. So I hope that you read those cases, because I will only discuss here the important principles from those cases. So good faith, guys. In the case of Carbonell, we see there that the knowledge of the first buyer about the second sale will not necessarily defeat that first buyer's right. Why? Eh, di ba, knowledge of a sale will uh, make the buyer in bad faith. Kung mupadayon siya sa sale na wala siya na siya knowledge that there was another sale made. So even if that's the case, if the second buyer is able to register the sale in good faith ahead of the first buyer, then what will happen is that we prefer the registrant, the first registrant in good faith. So that's the time when the first rule of preference of the first registrant in good faith is applied. So even if kamao na ha, si first buyer na baligya to the second buyer ang same property, but from the time of the second sale up until the time of registration of that second sale, there was no showing that the second buyer was in bad faith or had knowledge of the first sale. So the knowledge, however, guys, acquired by the first buyer does not bar that first buyer from availing of his rights or his or her rights or remedies under the law. Among them, to register first his purchase as against the second buyer. So for example, si first buyer nakibaw siya nga naay second sale, but wala pa siya na register. Pag pa-register niya, nakauna siya with knowledge that there was a second sale. So the first buyer here was able to register the first sale ahead of the second sale, is given preference and is entitled to the property. But it's a different rule, guys. If the knowledge is acquired by the second buyer as to the first sale, yeah, regardless if he was able to cause the registration of the sale, but the first buyer is able to prove that the second buyer was in bad faith, kay kabaw na siya sa first sale, then that knowledge is tainted, and that will make the second buyer in bad faith. So in other words, guys, Article 1544 is addressed in particular to the second buyer to do a positive act, which is to register the sale, and that registration of the sale must be made and must always be in good faith. So a purchaser in good faith or an innocent purchaser for value is one who buys the property of another without notice that some other person has a right or interest in such property and pays a full and fair price for the same at the time of the purchase or before notice of the claim or interest of some other person in the property. So the one who asserts the status of a purchaser in good faith and for value has the burden of proving such assertion. So that was good faith. Bad faith, on the other hand, is a buyer is considered as one in bad faith if there is an adverse claim, a lis pendens, or when the person who is selling the property is not the one in possession, or any other circumstance that would arise which should place a prudent man on guard. So if the buyer will proceed with the property despite those circumstances, guys, then there is a showing of bad faith kung wala nag due diligence si buyer. And in the case of Limket Sons Milling Incorporated versus Court of Appeals, take note that the stipulations in the deed of sale can actually indicate bad faith on the part of the buyer. So the court ruled here that the language of the deed of sale may show bad faith on the part of the buyer because in the deed, instead of the buyer insisting that the seller guarantee its title to the land and recognize the right of the buyer to proceed against the seller if the title to the land turns out to be defective, ang ilang deed of sale instead provides that any losses which the buyer may incur in the event that the title is vested in another person are to be borne by the buyer alone. This indicates, guys, na gi-waive niya ang warranty against eviction. And the only instance that this would be placed in a deed of sale will be kung kay bao si buyer nga questionable ang title or ang right or interest sa seller, but willing siya mo risk or mo gamble gid siya makapalit sa property. So si seller will only sold or entered into the deed of sale on the condition that the buyer will bear his loss. So that's an indication to the court that the buyer was in bad faith or had knowledge. Contrary man siya sa ato ang legal standard that the seller warrants against eviction. So be careful when you draft a contract of sale. Make sure na it is consistent with legal standards because future litigation might happen and that very same contract you drafted might be used against your client. So it's better nga you don't deviate from the legal standards. So question. On January 10, 2000, Raul sold a parcel of registered land to Eddie. On January 25, 2004, he sold the same land to Pink. Who has a better right if the first sale is registered ahead of the second sale with knowledge of the latter? And second question. If the second sale is registered ahead of the first sale with knowledge of the latter. So yun, kaya pag-answer, no? Bawal na mas answer, ani? So the knowledge of the first buyer will not affect his status as a first registrant in good faith, as long as he's able to register it ahead of the second buyer. So the second question, the buyer here is considered as one in bad faith. Kaya na naman siya prior knowledge of the first sale, even if nakauna siya pa-register. So dagag board questions guys on double sales. So I hope you master this particular topic. So what happened in the case of Naawan Community Rural Bank versus CA? So in this case, guys, Guillermo Comayas obtained a loan from Naawan Bank and mortgaged his house and lot. So this particular lot that was mortgaged was actually declared sa tax declaration in the name of Sergio Balibay. And this declared owner in the tax declaration authorized the Comayas to mortgage the lot. But Comayas was unable to pay the loan, so the bank foreclosed on the mortgage. Meanwhile, however, the lot was registered and na-issuehan og original certificate of title. So the lot was became registered in the name of Comayas. So in 1986, after foreclosure of Naawan Bank, the 1-year period of redemption lapsed. So the bank was able to get a sheriff's deed of final conveyance. Okay, and this deed of final conveyance was registered under Act 3344. Pinagtuo si Naawan Bank na unregistered pa siya. So by virtue of the deed of conveyance from the sheriff, the bank was able to obtain a tax declaration in its name for the house and lot. However, kaning si Comayas, pag 1988, despite failure to redeem the property, was able to sell it to spouses Lumo. And they registered a sale, and a TCT, a transfer certificate of title, was issued in their name. When they tried to obtain a tax declaration for the lot, they were surprised to find out that the lot was declared in the name of the bank. So of course, litigation commenced, and the bank argues that it is the first registrant in good faith. Kaya na-register Manila ang deed of final conveyance under Act 3344. And it should prevail over the later registration of the buyers ni Comayas, kaning spouses Lumo. So the bank argued that registration under Act 3344 of the sheriff's deed of final conveyance amounted to constructive notice. So issue for resolution by you guys. Who has a better right? So the court ruled here that the spouses Lumo had better rights. So at the time of the execution and delivery of the sheriff's deed of final conveyance on September 5, 1986, the disputed property was already covered by the Land Registration Act. Thus, from April 17, 1984, the property was already under the operation of the Torrent system. And under the said system, registration is the operative act which gives validity to the transfer or creates a lien upon the land. So the effect of issuance of the certificate of title is to relieve the land from all claims except those noted thereon. So accordingly, private respondents in dealing with the subject registered land were not required by law to go beyond the title to determine the legal condition of the property. They were only charged with notice of such burdens on the property as were noted on the register or the certificate of title. So as already discussed, the rule on the rule of preference in case of double sales in Article 1544 will not apply to unregistered lands. So question is, what are the rules therefore kung unregistered land ang na-double sale? So I assign a case for this, the case of Karumba versus Court of Appeals. So we see here that the rules are Section 33, Rule 39 of the Rules of Court, and the pertinent provisions of Act 3344. So in the first case, guys, Naval versus Court of Appeals, in 1969, Ildefonso Naval sold a parcel of land to Gregoria Galarosa, and this sale was recorded under Act 3344. Gregorio, the buyer, in turn sold portions of the land to Conrado in 1976, to Jaime and the spouses Moya in 1977, and again in 1987, he sold portions to Juanito. All buyers occupied the portion that they bought. They built improvements on their portions and they paid the taxes corresponding to their portions. However, in 1975, an OCT was issued to Juanita Naval, the granddaughter of Ildefonso, katong gipalitan ni Gregorio. And she claims here that she bought the property from her grandfather back in 1972. So, napalit niya after ni Gregorio. In 1997, Juanita, wanting to recover the land, sued Conrado, Jaime, the spouses Moya, and Juanito. So the court here, when it resolved the complaint by Juanita, applied Article 1544 and gave preference to Gregorio's buyers because of the prior registration of the deed of sale between Ildefonso and Gregorio. So they held that such registration was constructive notice to the subsequent buyers. So issue for resolution, guys, is the rule of preference in double sales in Article 1544 applicable to this particular situation? So Supreme Court held no. Article 1544 is inapplicable to the case at bar since the subject land was unregistered at the time of the first sale. So the registration contemplated under this provision has been held to refer to the torrent system na registration. So the applicable law therefore, guys, is Act 3344, which provides for the registration of all instruments on land neither covered by the Spanish mortgage law nor the torrent system. And under this law, the registration by the first buyer is constructive notice to the second buyer that can defeat his right as such buyer in good faith. So take note, first sale sa case sa Naval was unregistered siyang land. And the alleged sale to the granddaughter ikuha pa man siya og OCT for that. So we don't apply the rules in Article 1544. In this second case, in Karumba versus Court of Appeals, in 1955, the spouses A and B sold to C a parcel of unregistered land for the sum of 350 pesos. The deed of sale was not registered. but C was able to take possession of the property in good faith and has been in possession of that property ever since. Later, a decision was rendered against the sellers, the spouses A and B, in favor of D in a civil case filed in 1957. So the land sold to C was levied upon and subsequently sold to D in the sheriff sale. So si D ang nakabalit sa property after the execution sale was able to register the sheriff's deed of sale in good faith. So who has the better right to the property in dispute? Is it C or D? So C, guys, has the better right over the disputed property. Why? Di ba unregistered man to? So the rule in Article 1544 applies to lands covered by Torrens title, where the prior sale is neither recorded nor known to the execution purchaser prior to the levy, but where the land in question is not registered under Act 496, the rule is different. The purchaser of unregistered land at a sheriff's execution sale only steps into the shoes of the judgment debtor and merely acquires the latter's interest in the property sold as of the time that the property was levied upon, as provided in Section 35 of Rule 39 of the Rules of Court. So, wala nila gi-apply si 1544 kay unregistered landman. But, ang rule sa Rules of Court. And remember that katong sa prior na itong discussion na you only step into the shoes of the seller. So, itong article, remember pa mga to. Nakalimut ako sa article. So, just review So, what happened in this case? Dagupan Trading Company versus Macam. So, si Sammy Maron and his 7 brothers and sisters were pro indiviso owners of a parcel of unregistered land. So, they applied for registration under Act 496. However, while the application was pending, they sold the land to Rustico Macam, who was able to take possession. A month later, an OCT was issued in the name of the Marons, free from all liens and encumbrances. So, one creditor, however, of Sammy Maron, Manila Supply and Trading Company, was able to obtain a judgment against him. So, gilevy niya ang property and it was sold at public auction, and Manila Supply and Trading Company was the winning bidder. So none of the Marons redeemed the property. So the creditor was able to consolidate title and a TCT was issued in its name. So si Manila Supply, iya dayong gibaligya to Dagupan Trading Company. Okay, so kagubot sila kay gibaligya naman ni Maron siblings, diba, to Rustico Macam. So who has a better right? Dagupan Trading Company or Rustico Macam? Court ruled here that it was Rustico Macam who had better right. So once again, wala gi-apply ang rule on double sales since the sale to Macam was while the land was still unregistered. While ang katong second sale while the subsequent sale to Dagupan Trading by Manila Supply was already when the property was registered na. So court ruled here that it is our considered view that what should determine the issue are the provisions of the last paragraph of Section 35, Rule 39, to the effect that upon the execution and delivery of the final certificate of sale in favor of the purchaser of land sold in an execution sale, such purchaser shall be substituted only to acquire all the right, title, interest, and claim of the judgment debtor to the property as of the time of the levy. So at the time of the execution, Sammy Maron no longer had any interest in the property. So the judgment rendered against him in favor of Manila Trading was void and of no effect. How about in spouses Sabitsana versus Muertegui? So in this case, guys, Alberto Garcia sold unregistered land to Juanito Muertegui. And this was in unnotarized deed of sale. So the buyers were able to take possession. They cultivated the lot. They paid the taxes on the lot. Okay, but the seller, Garcia, sold the lot to the family lawyer, attorney Sabitsana. And the sale was registered and TCT was issued to attorney Sabitsana. Si attorney also paid taxes and made improvements on the property. Anong wala siya o sila nag-abot ano no? Introduce mag-improvement si attorney Sabitsana nga naaman ang Muertegui sa property sad. So when the Muertegui family attempted to register their sale, attorney Sabitsana opposed the registration. So the Muerteguis filed a suit for quieting of title. The trial court ruled in favor of the Muerteguis, and they said that the registration by attorney Sabitsana was in bad faith since he knew of the first sale. Kaya siya may family lawyer sa Garcias. So on appeal, attorney Sabitsana argued that 1544 was not applicable to unregistered land. Instead, the provisions of PD 1529 should apply. So that being his argument, he said na the deed of sale in favor of Juanito is valid only as between him and the seller Garcia, pursuant to section 113 of PD 1529. And it cannot affect other parties who are other persons who are strangers to that deed of sale between Juanito and Garcia. Kaya di ba, waman ni siya na panotaryo ang deed of sale kay Muertegui. So, is Article 1544 applicable as argued by attorney? Is it applicable or is it not as argued by attorney Sabitsana? So the court ruled here that 1544 will not apply to sales involving unregistered land. So the issue of the buyer's good or bad faith is relevant only when the subject of the sale is registered land and the purchaser is buying it from the registered owner whose title to the land is clean. So what the court applied here is Act 3344. Okay, and Act 3344 expressly declares that any registration made shall be without prejudice to a third party with a better right. So applying that particular provision in 3344, guys, the court held that the sale to respondent Juanito was executed on September 2, 1981. And this was through an unnotarized deed of sale. Well, the sale to attorney Sabitsana was made via a notarized document only on October 17, 1991, or 10 years after the first sale. Thus, Juanito, who was the first buyer, has a better right to the lot, while the subsequent sale to petitioner is null and void because when it was made, the seller Garcia was no longer the owner of the lot. Right? So, dili day material ang good faith, bad faith when it comes to unregistered land. Okay, in Radio Wealth Finance versus Palilio, A sold a piece of unregistered land to B, and B immediately took possession and made improvements while the registration proceedings were still pending. The deed of sale, however, was not registered. A month later, the original certificate of title was issued, still in the name of the seller, the name of A, free from all liens and encumbrances. Okay. Subsequently, the same land was sold at public auction to satisfy the debt of A to C, the judgment creditor. So si C, siya may nakapalit, was able to register the certificate of sale by the sheriff and certificate of final sale. C thereafter sold the property to D, who then sued B to recover the property. So who has a better right? B or D? So B here has a better right to the property than D. The court ruled here that the purchaser of land sold in an execution sale shall be substituted to and acquire only the rights and interests of the judgment debtor at the time of the levy. So since A, the judgment debtor, was no longer the owner, then he could transmit no rights to C, and C could transmit no rights to D. So D acquired nothing. The unregistered sale and subsequent transfer of the title and ownership to B could not have been rendered of no effect by the subsequent issuance of the torrent's title to the land. Besides, to deprive B now of the land and the improvements made thereon by sheer force of technicality would be both unjust and inequitable. What happened here, guys? Di ba once ma-sued siya sa torrent system, kay malimpyo man, ma-relieve man ang property of any and all claims whatsoever, except those annotated thereon? What makes this case unique? You find out, ha? So to summarize the rules, guys, take note that in the Sabitsana case, first sale was unregistered land. The second sale was still unregistered land, but the land was subsequently registered under the torrent system by the second buyer. So the rule applied was Article 3344. Registration made shall be without prejudice to a third party with a better right. The Naval case, guys, unregistered land ang first sale, but sale was registered under Act 3344. Second sale, unregistered gihapon, but subsequently registered under the storing system by the second buyer. So, applicable rule, Act 3344 gihapon. Registration by the first buyer is constructive notice to the second buyer that can defeat his right as such buyer in good faith. In Karumba, unregistered land sa first sale. Then second sale was at an execution sale and still unregistered siya. The land was subsequently registered under the torrent system by the second buyer, and that second buyer sold it to another. So the court ruled here, ang applicable rule kay Section 33, Rule 39, 33 ba 35? Check lang Ilain-lain na ako ang kung ano, gisite na section. In the Gupan Trading and Radio Wealth Finance na cases, guys, first sale was unregistered land. But sa second sale, guys, the registered land na parehistro na ang property at the time of the execution sale. So the judgment creditor was able to register the sale and sold the land thereafter. So applicable rule, guys, in these two cases was still the rules of court, even if registered land na siya. even if it was already registered at the time of the sale. I-apply gihapon ang rules of court. So to summarize the rules, if registered land, first priority will be 1529. And second priority ang Article 1544. If it is unregistered land, we apply Section 33, Rule 39 of the Rules of Court or Act 3344. Then second priority lang ang 1544. Okay, so that concludes our discussion with regards to the rules of preference in double sales.